Mr. Shroff, we're to understand now from the text of the ordinance that it is not just willful defaulters that will not be allowed to bid in the insolvency process, but even those promoters or those who have their accounts classified as non-performing assets for 1 year or more and are unable to settle their overdue amounts, including interest thereon and charges related to the account, before the submission of the resolution plan. In short, promoters of insolvent assets cannot participate. Correct, sir?
That is correct. That is correct.
How do you view this development?
They will not be eligible. I think they have taken a fairly strict view, which is sort of, in some sense, is a harsh view of who can't participate. Because ultimately, if you look at it as an extension of an SDR or CDR process, there they were giving haircuts to people who were promoters, who were settling their sort of, settlement or working out a plan on principles which are part of RBI guidelines and RBI processes. Whereas now they're taking up a position that even if such a scheme was there, if you have not paid, you are not eligible.
So a couple of things on this point itself, because there are many other types of people who have been left out of the process, and I'll get to that in just a bit. But is there any scope here? Because they have said that before submission of resolution plan.
Yes.
So is there scope here for the next few accounts, and you and I both know what we're talking about, for the promoters of those companies that are in the insolvency process to try and come to some sort of very quick agreement with the creditors, and thereby permitting them to be part of the resolution plan process?
No, what they will have to then do is to come to a resolution of the overdue amounts and interest and scale it down and pay up that scaled amount. The consequence of the second element of Section 29 regarding the eligibility would mean that if they were non-performing assets for 1 year or more, then the word is and unable to settle their overdue amounts. So there is a requirement of settling overdue amounts. So what can happen before they're filed, before the CIR process is commenced, is that they scale it down and they pay. So if they bring in some third-party white knight, effectively at a stage prior to the CIR process and have a settled value, they can have a valuation paid up so as to clean up all default, and assuming satisfaction of overdue amount and interest as scaled down, if they paid before the resolution plan, there is no issue.
The process, did you say this would have to happen on, or what is the timing requirement?
No, this time the ordinance will be effective immediately.
No. So what I mean is that suppose it's, let me give you a hypothetical example.
Yeah.
There is a company that is already in the insolvency process. Let's assume that the resolution professional has called for resolution plans, and plans are in the process of being submitted. There is a deadline pending, after which the resolution professional will take those plans to the committee of creditors. At this point, if you are a promoter who has not settled his previous defaults, do you have scope or time to do so right now?
No, because the word uses before submission of the resolution plan. So if they have submitted a resolution plan and their overdue amounts are standing, they will be ineligible. If they have done it, supposing the CIR process has begun, but before the resolution plan they made the payment of overdue amount including interest, then yes. But if they have already submitted a resolution plan, then no.
Okay, so if they've not submitted a resolution plan, they still have a window of opportunity, whether it's 24 hours, 1 week or 1 month, to be able to find some way of paying back the defaulted amount, however they source that money, and then being allowed to participate in the resolution plan. Correct, sir? But, sir, this is an oxymoron, because if you had the money to pay back the defaulted amount, would you not have already settled all of this before the company went into insolvency?
Yeah, so you did not settle because there was no pressure of being evicted.
Okay. So this adds a level of pressure.
Of course, it puts a level of pressure. It is clearly intended to knock off people who are basically defaulted. And this is in that overarching principle that they don't want anybody to misuse the thing. Because that's the third statement. If you see the press release which has come out, it says along with other steps towards improving compliances, actions against defaulting companies to prevent misuse of corporate structures for diversion of funds, reforms in the banking system, weeding out of unscrupulous elements from the resolution process is part of ongoing reforms of the government. These would help strengthen the formal economy and encourage honest businesses and budding entrepreneurs to work in a trustworthy, predictable regulatory environment. So their intention is essentially to knock off all those people who have fiddled with the system.
You regularize the irregular portion, and for the regular portion, then you choose the insolvency process for relief. Is that something that you agree with?
Yeah, that is a possible interpretation. I have the ordinance now in my hand.
Okay.
The language used is, this is in 29AC, whose account is classified as a non-performing asset in accordance with the guidelines of the Reserve Bank of India issued under the Banking Regulation Act, and the period of 1 year or more has lapsed from the date of such classification, and who has failed to make payment of all overdue amounts with interest thereon and charges relating to non-performing asset before submission of the resolution plan. So if the word used is overdue amounts, it may not, a principal may be still outstanding if it is not accelerated. So overdue amounts has a different meaning from just a language which they had put in the press release, because that the words are slightly different in the text of the ordinance.
So what does this effectively mean, sir? Can you tell us, Mr. Shroff, in an insolvency process, if an asset has already gone to insolvency, is there any scope for the promoter to now correct or rectify the situation and participate, or has that window closed altogether?
No. He can if he pays overdue amount, which is basically not necessarily principal, the full of entirety. That's what Mr. Kannan said, that look, there may be a portion which is still due in future. Unless it is accelerated, unless all of it has become payable immediately, then there is no chance whatsoever. But if only a part of the overdue amounts, as in principal or interest or cost, which are usually part of a legal notice, if that is quantified and the promoter pays up that amount, then he has a scope of going under a resolution plan and seeking deferral on the basis that I want the company to be viable. Because the other stress in the ordinance is clear that you have to look at the viability of the resolution plan. So it's possible to construct it in the way Mr. Kannan said, that you may ask for the regular process. It's like a modification of the contractual documents in a resolution plan.
Mr. Shroff, I'm trying very hard to keep up with you. I know this is a little bit more legal than even my understanding. But my simple question to you is this. We have two big accounts right now at the resolution plan stage or almost there, which is Bhushan Steel and SR Steel. In these two accounts, I'm not asking you to tell me whether it's a good thing or a bad thing, but can you just explain to me whether the promoters will be able to participate in this resolution process?
No, unless and until they pay up all the amounts, no.
They will not be able to. And
No.
do they have time to pay up?
Yeah, they have I think even that is not possible, because it says before the submission of the resolution plan. So assuming that the promoters have not submitted a plan, then yes, they have a window. If they have already submitted a resolution plan, they have no window.
Okay, and if somebody else has submitted a resolution plan but they have not yet submitted, is there scope there also?
No, because if they have submitted, if they have not submitted, there is scope.
Okay.
If somebody else has submitted, it does not affect any of the disqualification concerning the promoters, because a third party making a resolution plan is not relevant for the purpose of 29 capital AC. It's only their own submission plan which is relevant for the disqualification.
Mr. Shroff, the other category of people that are ineligible are one, and I'll describe this to you. I don't have the exact wording of the ordinance, but I'm going by what the Finance Ministry has put out. Those who have executed an enforceable guarantee in favor of a creditor in respect of a corporate debtor undergoing a corporate insolvency resolution process or liquidation process under the code. What exactly does that mean, sir?
See, there are 8 categories of persons which have been disqualified, not just 4. In the ordinance, there are many more categories which are disqualified. Let me read out section 29A. A person shall not be eligible to submit a resolution plan if such person, or any other person acting jointly with such person, or any person who is a promoter or in management or control of such person. The first category is an undischarged insolvent. Second category is a willful defaulter against in relation to the guidelines of RBI. Third category is what we have been discussing, that whose account is classified as a non-performing asset and a period of 1 year or more has lapsed on the date. and who has failed to make payment of all overdue amounts with interest thereon and charges relating to the non-performing assets before the submission of the plan. Fourth category has been convicted for an offence punishable with imprisonment of 2 years or more. Fifth category has been disqualified as a director under the Companies Act. Sixth category has been prohibited by the SEBI from trading in securities or accessing the securities market. Seventh category has indulged in preferential transaction or undervalued transaction or fraudulent transaction in respect of which an order has been made by the adjudicating authority under this code. Next category has executed an enforceable guarantee in favor of the creditor in respect of a corporate debtor under insolvency resolution process or liquidation under this code. Last category is where any connected person in respect of such person meets any of the criteria specified in clauses A to H. And then they've given an explanation as to what is meant by a connected person. Any person who is a promoter or in the management or control of the resolution application. This is to deal with that fraudulent case which is in appeal. Any person who is a promoter and management or control of the resolution applicant, any person who shall be a promoter or in management or control of the business of the corporate debtor during the implementation of the resolution plan, the holding company, subsidiary, associate company or related party of such a person, and lastly has been subject to any disability corresponding to clauses A to I under any law in a jurisdiction outside India. So it's a far more stricter law, stricter positioning than what is in the press release. This is a much more expanded provision, and it really tries to knock off everybody who's sort of taken advantage of the banking system and or has been fraudulent in any way. So it's not only relating to fraud in relation to the company, but fraud generally, disqualifications generally, convictions generally, it's much wider.
Do you expect this to hurt the price discovery process of the bidding process for these assets? Mr. Shroff, there was one expectation that those promoters desirous of being able to hold on to their assets would attempt to bid quite aggressively. Also the argument that they are in better know and understanding of their asset than any outside bidder, especially if it is an unlisted company, and therefore they have a better idea of the contingencies, the reps, warranties, all that bidders would have otherwise got in an ordinary M&A process. Do you think this might hurt the price discovery?
See, ultimately, Menaka, the test that has been put is viability rather than just a haircut. So the principle which the government has enunciated through this ordinance is that I want people who are going to run this project or process in a viable manner, not just some promoters already run it into the ground. And if you read Section 30, subsection 4, what they have done is, and they have impacted existing processes also. I'll read out what it says. Provided that the Committee of Creditors shall not approve a resolution plan submitted before the commencement of this ordinance, where the resolution applicant is ineligible under Section 29A and may, where there are no other resolution plan available with it, require the resolution professional to invite a fresh resolution plan. So what they're saying is that even if there was an application filed by any of the persons who are considered as disqualified before this ordinance, they will also be disqualified. So let's take a case that some of the promoters have already filed a resolution plan, but they're ineligible by virtue of this ordinance. That application plan would be treated as non-est. It would be treated as it's not available at all, and they would have to call for fresh application.
But so I understand the intent that you want to focus on viability. The question I'm asking you is, do you think it will hurt price discovery in any fashion?
See, if it is only limited to people outside, then ultimately there will still be people. Let me say, for example, take a case, what is reported like in JP Industries. There are 18 proposals. So if you can't discover price in 18 proposals, then you'll never discover price. And you can't say that the old promoter is the price leader. I don't think it would be right or fair to say that the existing promoter is going to be the price leader in a price discovery system, even if he has asymmetrical knowledge and he has sort of in possession of much more information than what a third party would have. So the reasoning seems to have gone on the basis that is it feasible, is it viable? The second test is what is the least haircut. But the critical issue is, and that's why they've amended the whole, put the responsibility of viability and feasibility. They have not gone on a haircut test.
Mr. Shroff, do you think that promoters have any grounds to challenge this in the Supreme Court?
Very difficult to challenge, because look at it from the perspective of the mischief that is sought to be remedied. None of the persons who have been disqualified are people who don't share the blame. Because ultimately when you ask for a haircut which is 40%, 50%, 60%, and you are the cause of that non-performance, which impacts the banking system, the sympathy will not be with the promoter. Look at it in equity. Ultimately, the courts are acting on principles of equity. If the person has caused this kind of injury to the banking system, would it not be prudent to keep such a person out if the test they will apply? And if they apply that sort of test, then yes, the dice are loaded against the promoters.
I understand as well as I do, Mr. Shroff, that in many cases, many of these projects or companies have run into trouble on account of circumstances not in the control of the promoter. For instance, if you were to talk to the Ruyas, they would argue that at SR Steel, one of the big problems they faced was the cancellation of the gas supply, which was not in their hands. The government arbitrarily decided to pull back on the gas supply, as a result of which their project got delayed by several years and there were cost overruns. My question is, whilst the Supreme Court overall may not be inclined to indulge those promoters that have taken the banking system for a ride, you cannot broad brush this. Many promoters would seek to be heard on the merits of their own case. And therefore, do you think that there could be grounds for some promoters to find relief in this?
See, the question, Menaka, if you read that 29AC, it says that if the period of 1 year or more has lapsed from the date of classification as a non-performing asset. So if you had all these grievances, then you could have made these grievances to the Reserve Bank, to the promoters, to the bankers at that point of time, and said that these are beyond my control. But if despite all that it has been classified as a non-performing asset, then I don't think this argument will stand, because this clause is absolute. It is not subject to causes. Causation is not a part of 29 capital AC. What I'm trying to say is that the exception to the rule that I have to be permitted to participate in a insolvency resolution process where I can ask 50-60% haircut for reasons beyond my control, the flip side is it is also beyond the control of the bank. And it's a both-way clause. Why would the banking system take such a loss? Because the loss falls where it falls. That would be the law.
There is one criteria of ineligibility which says has executed an enforceable guarantee in favor of a creditor in respect of a corporate debtor under insolvency resolution process or liquidation under this code. Exactly who does this leave out of the process?
No, this is basically third-party guarantors who have assured the performance and the payment dues of banks from the corporate debtor. There is a link which is missing, and that is something which I'd like to read out, that in Section 2, subclause E, they have split the subsection into 3 subsections, and what is happening is that the personal guarantors to corporate debtors, effectively action against them will also be subject to a moratorium. So the claims against the guarantors effectively will get discharged. That would be my reading of how this amendment works, because one of the principles which we were sort of debating was that if the principal debtor is getting a resolution plan, have I an independent right against the guarantors? So they seem to have done something positive in that they have clubbed the insolvent company or the resolution company in the same class they've brought in personal guarantors. So you can't take action against personal guarantors when the scheme of resolution is under preparation, and there will effectively be a discharge. In relation to winding up, the position may be different, but in relation to the CIR, the moratorium will therefore apply to even the guarantors, and therefore the guarantors are getting a benefit under this law, and because they're getting a benefit, the same principle or the same paint effectively is being applied to guarantors that, look, if I'm not going to recover from you, you are not eligible to also bid. That's the logic.
Okay, sir, could you explain that in a little simpler English or through an illustration? So, if we were to take, I think almost all promoters, often on a personal level, offer guarantees to loans taken by their companies. So, is this applicable to those situations? Is there an illustration that you can use to help us understand this?
No, Menaka. Menaka, take a situation where a company's promoter is, say, the Ruyas, for the argument's sake. And let's take a situation that Mr. Khaitan has given a guarantee for SR Steel, and therefore the promoters are per se barred by virtue of the non-performing asset paragraph C, but in relation to the guarantees, Mr. Khaitan would be the beneficiary because his guarantee would also be subject to a moratorium during the period of the rehabilitation scheme, the resolution plan. Now, if therefore, the section therefore 29A says that if Mr. Khaitan has executed an enforceable guarantee in favor of a creditor, namely the banks, in respect of a corporate debtor, namely the SR Steel, under insolvency resolution process, then Mr. Khaitan can't make a resolution plan.
Okay. So this is an effort, if I was to broadly look at it, this is an effort to not just block the party that is directly the promoter, but any layers above the promoter or related to the promoter that may have offered guarantees, because those are typically the ones that end up offering guarantees on loans, right, sir?
That is true. And I think this is also, there is another principle involved here. What they're saying is if you're getting an advantage under the IBC, whether by way of a moratorium, whether by way of a haircut, whether by way of a complete stay, if you're a beneficiary of the law, which gives you a reduction of debt, you can't be an applicant.
All right. So in your opinion, Mr. Shroff, there is absolutely, at this point in time, based on this current reading, no scope or no gap that would allow a defaulting promoter to participate directly or indirectly in the resolution process, right, sir?
Unless he pays up the overdue amount.
Yeah, well, if he had the money, then he would have resolved this much before it went to insolvency. But yeah, I suppose if he still has a small window of opportunity in this process. You expect that many of these promoters will go to court to appeal against this?
They will go to court because I think they will argue the point that there is retrospectivity in the ordinance, in a sense that even if we were at an advanced stage and somebody who has filed a resolution plan might take up the principle of retrospectively. Somebody might take up the issue that there is a time limit within which resolution plans have to be filed, and they have not dealt with how the time limit gets expanded if there are no valid resolution plans. Because what I had read out to you under subsection 30 subclause 4 or section 30 subclause 4, they proceed on the basis that if you are not eligible and no resolution plan is available, then the resolution plan profession is to invite further resolution plans. But if it is sort of getting beyond the time, because there's a time limit within which the COC has to get all things approved, and that time limit is hardbound and hardwired at 270 days. So depending upon what phase the stage is, there might be some amount of problems on the retrospective applicability of section 30 subclause 4, read with 29A. So there are some openings which could be there, but they're fact-based. They're not law-based. They're actually based on what are the facts of that particular case.
All right, then we'll see how promoters react to this. Mr. Shroff, you've spent considerable time explaining to us the minutiae of this ordinance. We appreciate it deeply. Thank you very much for joining us, sir.